All right, good morning, everyone. This is the civil calendar for Thursday, March 6th, or February 6th, sorry, with Judge Krause in Superior Court. We have a fairly short calendar this morning. I think there's really only two matters in the morning session. I don't think we have a court reporter. If we do have a court reporter, if they would please identify themselves, but I don't think we do. Okay. I see Mr. Rowland and Ms. Fallon. Do we have someone here? Mr. Suarez, are you here on the Flower Magazine matter?
Yes, sir, that's right.
Okay. And Ms. Humphreys.
When it says Miss Humphreys, that's my client, which is David Harris. So he was having some trouble, and I think he's logged into a relative's account. So
Okay, I will manually rename him for the clarity of
yes,
the judge.
perfect.
Okay.
I didn't even know you could do that, so that's
I
great.
can.
Thank you.
All right, so I believe the judge will be with us momentarily, and if everyone just sit tight. Always remain muted until she calls on you, then remember to unmute and give your announcements. All right, get underway in a second here.
Good morning.
Hello.
Hi, Mr. Fallon.
Hi, how are you?
Good. Okay, I'm just going to give everybody sort of a minute to get logged on. Okay, so I just have two matters for this morning. First up is the Flower Magazine case versus Young and Meath Homes. Who do I have here on that matter?
Yes, Your Honor. This is Andrew Suarez here for Plaintiff Flower Magazine.
Hi, Mr. Suarez. I saw that you had submitted some additional affidavits, and I think I saw that you had filed. I think the last time we met, what we had discussed was it appeared to me that the defendant was in fact in default, but that I didn't have any the damages or other information I would need to enter a final default judgment. And it looks like what I've seen is that you have endeavored to provide that information. So I'm going to let you walk me through that in just a moment. Okay.
Perfect.
How long do you think that will take, Mr. Suarez?
Less than 10 minutes.
Okay. Thank you. And then I have Ms. Rowland and Mr. Fallon here on the Concourse Acquisition Development versus David Harris and First Standard Assurity.
Yes, Your Honor.
Okay. For the pretrial conference, correct?
That is correct.
Okay. These are the only two matters I have at just this slot. So I'm going to go ahead and let Mr. Suarez go. I see that I have looks like Chandra Kern and Stephen Kern on the call. If y'all are, so just to let you know, your matter was moved from today's calendar because the interpleading entity, I think the sheriff's office, wanted to make additional efforts to secure service on you and Ms. Kern. And so that matter has been moved, I think, by approximately a month to 2 months to allow the process of service to proceed.
Okay, we did get the service, but we did see that there was another judgment issued yesterday. So
So
I don't understand.
unfortunately, I apologize, Mr. Kern. I can't really talk to you substantively about the case because no one else is here in that matter because it was moved from the calendar. What generally happens, I can tell you without giving you legal advice, is that in an interpleader, what will happen is the sheriff will identify every single person who might have an interest in the proceeds of the funds that were obtained from the tax sale. And they identify every single person or entity that might have an interest. And then I believe anything that I believe what I might have signed recently was something allowing service and or allowing maybe one of the entities who had been served or sued to be removed from the case because they didn't have a claim. But I'm not going to enter a final judgment dispersing any funds to anyone until I'm confident that everyone has been served and had an opportunity to make a claim to those proceeds to the extent that anyone has a claim. And so if you are not required to acknowledge service, but if you choose to do so, then I would encourage you to reach out to the lawyer for the interpleading entity, because the reason the matter has been moved is that the lawyer is concerned that service was not secured on you and wanted to make sure that you received legal service.
Okay, I'll follow up with the that particular attorney.
Yes, sir. And other than that, you'll get the same notice that you got for today's hearing. You'll get another notice from us advising you that there will be a hearing on the merits of the varying claims as to who has claims to the funds.
Judge, just to jump in, wouldn't they have to file an answer to get notice? Because if they remain silent, they won't be in e-file Georgia. So
well,
they would need to be.
Those are their decisions. Either way, we're going to have a final hearing, and everyone that has appeared will have an opportunity to make a claim to the remainder funds. So, but thank you, Mr. Freehoff. It's a fair point. But Mr. Kern indicates that he was going to reach out to Mr. Adam Caskey, who is the lawyer for the sheriff in that case. Otherwise, I think their intention is to do service by publication. And that's about all I got. That's all just sort of public record. And you know, I'm not sharing with you anything that's not in the record or anything giving you legal advice of any kind. So
no, that's great. All right. So we'll follow up with them. We did file something into the court. We've been trying to file, I guess, Sir E. Tyler, I think, has been down, up and down the last couple weeks.
Yeah, that does happen. But I encourage you, if you have any issues, to reach out to the clerk's office. They sometimes can assist with those things.
Yeah. Okay, sounds good.
Thank you, Mr.
All right.
Kern.
So yeah, thank you so much.
You and Ms. Kern may be excused.
All right. Take care.
Thank you. Okay, Mr. Suarez, if you want to go ahead with your presentation regarding Flower Magazine.
Yes, Your Honor. What you'll see that we have provided for the court is an affidavit from the Chief Operations Officer for Flower Magazine. Her name is Mercy Lloyd. In this affidavit, she swears to the fact that there are 2 outstanding bills that Young and Meath Homes, despite having notice of, have failed to pay or otherwise respond to our request for payment. A demand letter was sent about 1.5 years ago, in fact. But specifically what we're showing now is that there was a contract in place signed between the parties. Signatory for Young and Meath Homes was Doug Beasley for provision of promotional services for this show house at 389 Blackland Road. The agreed upon amount for that promotional services that were provided and rendered was $65,000. In addition, under the terms of the contract, Flower Magazine provided certain additional, I'll characterize them as benefits. They provided work that was done through third-party contractors that Flower Magazine had relationships with here in Atlanta that Young and Meath Homes did not have a relationship with. In order to not hurt their business interests, Flower Magazine paid these amounts to these third parties and then sought reimbursement under the terms of the contract. The amount for that is $10,298 paid to 3 different third-party beneficiaries, Jim Shea Installation, Matthew Quinn Hardware, and Barry Dixon's Nailheads from Dakaya.
Okay,
And then,
go ahead.
and that's the liquidated damages. That's the damages under the contract. If you'd like me to proceed with attorney's fees or declaration that I provided as well, I'm happy to move forward there. Or if you have any questions about that first affidavit.
No, that first part was straightforward and it is acceptable to me. So go ahead.
Great. And Your Honor, what I've also provided is my own sworn declaration, just setting out what's been done since the initiation of the lawsuit, since filing it in Fulton Superior Court. I've provided my hourly rate that we charge here. I'm an associate attorney here at Ellerbe Thompson. My hourly rate is $315. Since the time of filing the lawsuit, I have put 29.9 hours into this matter, with a resultant fee of $9,418.50. In addition, we are seeking to recover the costs associated with service of process and service of process via the Georgia Secretary of State.
Okay. I am looking at the proposed order that you submitted. And it includes a proposed recovery of damages in the amount of $75,298.28, and then attorney's fees and costs in the amount of $9,578.40 for a total final judgment requested of $84,876.68. Is that correct?
That is
Mr.
correct.
Suarez?
Yes, Your Honor.
Okay. So as I said, when we previously met, it does appear to me that Young and Meath Homes were properly served and that more than 30 days passed and no answer was filed and they became in default, and more than 15 days has passed since they became in default. And therefore, Flower Magazine is entitled to a default judgment against Young and Meath Homes. And Flower Magazine today, and through its declaration filings, has provided the court with sufficient evidence to justify the damages requested in the amount of $84,876.68. And so what I will do, Mr. Suarez, is finalize the order that you've submitted and get that final default judgment on file for your client.
Thank you very much, Your Honor. I appreciate it.
Thank you. Anything else you need from me, Mr. Suarez?
No, have a great day. May I be
Okay,
excused?
thank you. You too. Okay, so I have you guys down on the Concourse Acquisition Development versus the Rothman defendants, Buck, Vaughn, et cetera. Now, a couple of things I want to clarify to make sure we're all on the same page. I did see the pretrial order that y'all sent over yesterday. As best I can tell from the activity in the record, the only parties left in this case are David Harris and First Standard as surety. Is that right, Mr. Fallon?
Yes.
Okay, Ms. Rowland, do you agree with that assessment?
That's correct.
Okay. So in preparing for the pretrial conference today, obviously I'm aware, and I know the parties had reached out and said, hey, Judge, we have a summary judgment motion pending. What's going to happen with that? And I have spent a great deal of time with it. It's not an uncomplicated motion and set of responses. What I wanted to let you guys know today is that I think I'm inclined to grant the defendant's motion for summary judgment. And the reason I'm telling you this now is because although I have spent a great deal of time with the information and I feel comfortable, and I'm going to outline for you in a moment the basis of my ruling, Ms. Rowland, I'm going to ask you to draft a proposed order for me and submit it to the court so that I can file it, edit it, and then get it filed. And so that Mr. Fallon, you can take whatever steps you want to take on behalf of your client. My review of the file, the reason I started with, let's make sure we're on the same page regarding who are the defendants in the case, is that if Mr. Harris and First Standard are the only defendants left in the case, then the only causes of action left are count 3 for fraud or misrepresentation and the associated derivative attorney's fees claim. Obviously, if the underlying claim fails, then the attorney's fee claim fails. my review of the fraud claim, I know there is an ancillary claim regarding a filing of a false UCC financing statement, but that doesn't involve First Standard or Mr. Harris. And that really the issue involving Harris and First Standard is this fraudulent bank confirmation letter. And let me be clear that I don't think there's any dispute from anybody that that letter is a fake, right? It seems to have been demonstrated to have been a fake. However, what there is not any evidence of, there is a great deal of supposition and a great deal of coincidence characterized by concourse about Mr. Harris and First Standard Surety's role in that letter coming into existence. But at the end of the day, there's not any evidence that directly ties the two of them together. But more significantly, it doesn't matter, sadly, even if they did directly obtain the fraud or, secure its existence or rely on it knowingly. The simple fact of the matter is that in deciding to close the loan, that letter didn't yet exist and hadn't been provided to anyone. And so the representations made therein, even if they're false, even if they're patently false, could not have been reasonably relied on for purposes of the elements of fraud. And additionally, to the extent that there was a merger clause, that's why, number one, I don't think that you can say you reasonably relied. And the existence of the merger clause, to me, I think forecloses any reliance on a subsequent representation or the representation even beforehand that a subsequent document would be provided. And then, excuse me, finally, and this is just the reasoning that I'm sharing with you so you'll understand why I'm ruling the way that I'm ruling. I'm looking at my notes and making sure I'm interpreting them correctly. Finally, I will say that the argument that this was or could have been fraudulent inducement, I think is defeated by the fact that I think the law is clear that you only have two choices. You can reject the contract in where a fraudulent inducement is asserted, or you can continue under the terms of the contract and argue breach. And what happened here is no one rejected the contract. And in fact, the contract existed for as long as it existed and was relied on and closed. And then all the funds were obtained, ownership was transferred, everything followed. And because there's no effort to undo it, I don't know that there is a legit basis to argue fraudulent inducement, particularly in these circumstances. And so, again, all of that is a lengthy way of saying this. I don't know the answer to whether Mr. Harris or First Standard Surety were involved in securing that letter. But what I do know is that by closing the loan prior to those representations having been made, it can't be said as a matter of law that there was a justifiable reliance on a letter that predated the closing, number one. And number two, there's no evidence in the record. Again, supposition, coincidence, inferences maybe that could be made, but there's no evidence in the record that's properly documented that ties Mr. Harris or First Standard Surety to that letter. And I know that there's an argument about whether or not Mr. Harris can be held individually liable because I'm ruling in the way I'm ruling, which is that First Standard, that there's just not evidence to support it. And even if there were misrepresentations, that it couldn't have been reasonably relied on or justifiably relied on. I don't have to reach whether or not Mr. Harris could be individually pursued for making such representations. So that is going to be my ruling. I understand that it will not be the end of my involvement in this case because I think I have another case assigned to me involving Rothman. And so I guess I will continue to deal with those issues there. Ms. Rowland, if you could please provide me with a proposed order. It doesn't, I want something that's got a little bit of meat to it, but it doesn't need to be. Hold on, I promise I'm gonna let y'all talk because mostly I've just been talking at you. But if you could provide me with a draft order in Word format that I can then edit. I will endeavor to make sure that it's on file for you guys by the end of next week. It might be sooner. I hope it will be sooner, but the end of next week might be the latest.
When do you
Mr.
need that, Judge?
Ms. Rowland, I'm sorry.
When do you need that proposed order?
Anytime in advance of me being able to get it on file by next Friday. So if you could get it to me by Friday or Monday of this week or next, I understand it might be better to have the weekend to do it. But yeah, Monday would be great.
Okay.
Thank you, Ms. Rowland. Did you have any questions or
No,
regarding my ruling?
I think a lot of what you said tracks what I've argued in the motion for summary judgment. So I think I should be able to deliver something along the lines of what you want. And of course it will be substantial.
Okay. Thank you, Ms. Rowland. Mr. Fallon.
Just a question,
Yes, sir.
Your Honor. You said that they could not have reasonably relied on because the loan went ahead and closed. And how is that different than if someone sold, say, for example, a car insurance policy that it turned out the guy didn't even work for the insurance company and just took your money and there was never any insurance, but you don't have an accident and then the term expires and so you didn't need the insurance and what you bought, never came into play.
Well, you're not wrong, Mr. Fallon. That was actually the example I used when I was sort of thinking it out, right? Which is this idea of if I buy car insurance and never have a claim, have I actually bought something that's worthless or been defrauded in some way? And for me, as I think your analogy is accurate to the facts of the case. It's just that the actual facts of the case, I think they might make one question what you've characterized, but the evidence in the record, as far as I was concerned, in terms of either having evidence or having undisputed evidence, didn't demonstrate that, in fact, that warranty was worthless, right? It didn't demonstrate that, in fact, First Standard and David Harris had sold something that was of no value. And that largely, it wasn't outcome determinative of my ruling, because ultimately as I understood the fraud claim, it was not targeted at they fraudulently sold me a product that didn't exist. It was they wrongly represented to me that they had fluid funds in a fraudulent letter. And if that's the fraud, right, then there is evidence of that fraud, but it post-dated the closing. And so that was the reasoning of my ruling. It mostly was tied, as I said, to whether or not the reliance could be justified as a matter of law, and whether or not the representations were tied directly to the existence of that letter, and its representations were tied directly to whether Mr. Harris or First Standard knew or should have known. And I was not satisfied that there was evidence in the record that they did know or should have known of the fraudulent representations in that letter. So that's going to be my ruling. Obviously, that sort of negates the need for us to do the pretrial order. But I, as I said, expect that I will see the parties again, or at least some of the parties again, related to the Rothman matter that is coming along, I think, more slowly. It was just newly filed, I think, and service was just recently accomplished on everybody. Is there anything else that the parties need from me other than for me to get an order on file for y'all to figure out what steps to take next?
Not from me, Your Honor.
Okay, Mr. Fallon?
Yeah, I don't think so. I guess I'll have more time to go over it when I see the order, and I
Yes,
think
sir.
Ms. Rowland understands it. If he didn't know about it, there's not enough evidence in the record that he knew about it, I think is what I heard you say. And so it was either him or the person he split the money with. Those were the only two. And they certainly weren't a party. This
Mr. Fallon, I understand that
From,
you disagree with
offshore, whatever.
my understanding of the facts, because I'm certain that you see it in a different way. And perhaps you will persuade the Court of Appeals that I was mistaken. But this
I
is
understand,
going to
yeah.
be my ruling. So,
Yeah, I
okay.
understand. Yeah, thank you very much.
Thank you all very much. Have a good day. I'll look for the order, and then once it gets on file, let me know what y'all decide to do.
Great, I'll get that in. Thank you.
Thank you all. Have a good day.
You too.